office of the deputy president is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions, perform any other functions of the president as the president may assign. 4. Unlike the vice president who was appointed by the president from among cabinet ministers who are elected members of the National Assembly, the deputy president under the 2010 Constitution is elected together with the president and holds no other public office. The above changes were not without reason. In the book, The Constitution of Kenya, commentary by Louis and PLO Lumumba, this is the second edition, Strathmore University Press, there 2019 at page 453. The two eminent authors had this to say, and I quote: with the other arms of government considerably weakened, the executive personified in the president exercised unchecked powers. Indeed, during the constitutional review process, the CKRC noted that the powers granted by the Constitution and the ordinary laws to the elected president seemed to share characteristics with those of the colonial governor. It then resolved during the constitutional making process to divest some powers from the president with the aim of avoiding an imperial president. End of quote. The above cannot be far from the truth. In the pre-2010 constitutional era, the president held immense powers, including the ability to appoint and dismiss the vice president at will, and the discretion to assign or to withhold duties for the vice president. Consequently, the vice president served entirely at the president's mercy. That was the framework that the 2010 Constitution sought to transform. Under the 2010 Constitution, the office of the deputy president has been fundamentally redefined. It is now safeguarded from arbitrary and capricious actions by the president. Article 172 grants the deputy president specific constitutional functions in addition to any duties the president may assign. This provision was intended to address the previous situation in which a president could, for any reason, choose not to assign any duties to the deputy president, effectively sidelining them. Thanks to the 2010 Constitution, even if the president does not assign any additional duties, the deputy president still has specific constitutionally mandated functions to perform. In this way, the deputy president is no longer at the mercy and the discretion of the president. Under the current constitutional framework, when the office of the deputy president becomes vacant, two outcomes flow. First, any functions that were assigned to the deputy president by the president automatically revert to the president. Second, the functions expressly conferred upon the deputy president by the Constitution do not revert to the president and cannot be performed by anyone else. This is a departure from the 1963 Constitution, under which the president could appoint a minister to act as vice president in the vice president's absence. The 2010 Constitution includes no such provision. Therefore, if the office of the deputy president is vacant, the specific constitutional functions assigned to that office remain unfulfilled. For clarity, not even the Speaker of the National Assembly may discharge the functions vested in the deputy president under Articles 147, Sub-Article 2 of the Constitution. In light of the above, we are convinced and hereby find that the current constitutional framework does not envision any scenario in which the office of the deputy president will remain vacant, except during the brief period required to fill such a vacancy. Another equally important provision that adds credence to the above position, that the office of the deputy president cannot be left vacant, is Article 146(3) of the 2010 Constitution. However, before we interrogate the said provision, suffice to note that Article 150, Sub-Article 2 of the Constitution, which is on the removal of the deputy president, has it that the provisions of Articles 144 and 145 relating to the removal of the president shall apply with the necessary modifications to the removal of the deputy president. Returning back to Article 146, which article deals with the vacancy in the office of the president. Sub-articles 1, 2, and 3 of that article provides that follows. These ones I'll read. Sub-article 1, the office of president, read deputy president, shall become vacant if the holder of the office dies, B, resigns, in writing addressed to the Speaker of the National Assembly, or otherwise ceases to hold office under Article 144, which deals with removal of president on grounds of incapacity, or Article 145, which deals with removal of president by impeachment, or under any other provision of the Constitution. Sub-article 2, when a vacancy occurs in the office of president or deputy, 1, the deputy president shall assume office as a president for the remainder of the term. 2, if the office of the deputy president is vacant or the deputy president is unable to assume the office of president, the Speaker of the National Assembly shall act as president, and an election to the office of president shall be held within 60 days after the vacancy arose in the office of president. Sub-article 3, a person who assumes the office of president under Clause 2A or following an election required by Clause 2B shall, unless otherwise removed from office under this Constitution, hold office until a newly elected president is sworn in following the next regularly scheduled election under Article 136, sub-article 2A. End of sub-article 3. Therefore, to us, a holistic reading of Article 146 alongside Article 152 of the 2010 Constitution, and in relation to the filling of a vacancy in the office of the deputy president in this matter, yields the meaning that the person who assumes the office after the impeachment of the deputy president shall, unless otherwise lawfully removed from this office, hold that office until further orders of this court or until the current term of the president ends, whichever comes first. The foregoing demonstrates that the structure of the Constitution, which reflects the popular will of Kenyan citizens, envisions a scenario in which the office of the deputy president will always be filled except during the brief period of required to fill the vacancy, as already stated above. Based on the foregoing, we now turn to the nature of the conservatory orders in this matter. It is widely accepted that the purpose of conservatory orders is to preserve the status quo pending further orders of this court. The Supreme Court in Gatirao Peter Munya and Dixon Mwenda Githinji and 2 others said as much. In this case, maintaining the status quo would mean, 1, that the first petitioner remains impeached under Article 145, sub-article 7, which affirms the finality of the impeachment process with the following provision, I quote, if at least 2/3 of all members of Senate vote to uphold an impeachment charge, the deputy president shall cease to hold office, end of quote. 2, additionally, the prevailing status quo will mean that the deputy president nominee, Professor Abraham Kithure Kindiki, does not assume office. With such an approach, while such an approach may seem fair, reasonable, and balanced, and one which this court would ordinarily be inclined to adopt, the unique nature of the deputy president role under the 2010 Constitution suggests a different course. Allowing these orders to stand will leave the office of the deputy president vacant. The problem, however, is that no other person is authorized to carry out the constitutional functions specifically assigned to the deputy president under Article 147, sub-article 2, once those assigned by the president revert to the president in the absence of an office holder. The result would be a de facto suspension of Article 147(2) of the Constitution, an outcome that no court should knowingly permit. For clarity, this court firmly holds that no court should issue orders that have the effect of suspending the operation of any provision of the Constitution, such